Good morning, good afternoon, good evening from Shanghai. This is Lin-Yang from Hong Kong International Arbitration Center. Welcome everybody to the second session of the HKIAC Chinese Arbitration Insights webinar series. And I hope all of you enjoyed our first session in the last month. As I mentioned in the first session, this is the first ever webinar series launched by HKIAC that specifically targets mainland Chinese arbitration relevant to offshore arbitration institutions. We will have 2 more sessions in the next 2 months. In the last session, we discussed the foreign-related elements and the governing law and the Chinese laws with 2 great guest speakers, Helen Shi and Mei Tai. Today's webinar is about the state of arbitration and the foreign arbitration institutions administering arbitrations in mainland China. The state of arbitration is very important. I might say the state of arbitration is the most important concept in international arbitration, which I'm sure that our guest speakers today will explain more about it. So HKIAC Shanghai Representative Office, where I'm right here now, is the first offshore international arbitration institutions office set up in mainland China. Since we set up our Shanghai office in 2015, we have received many questions like, is HKIAC Shanghai office able to administer cases in mainland China? Can we agree on our arbitration agreement that both parties should submit our dispute to HKIAC Shanghai office? Frankly, the answers to those questions are more than yes or no. For example, HKIAC could administer arbitration case fully online. The claimant could send the notice of arbitration via email rather than go to our physical offices. Actually, the parties do not need to show up in any HKIAC's physical offices in Hong Kong, Shanghai, and Seoul. This is one hand. On the other hand, Hong Kong as a seat means the Hong Kong court has the primary jurisdiction over the world. As you may know, Hong Kong court has a long tracking record in pro-arbitration. Besides, Hong Kong as a seat also means Hong Kong Arbitration Ordinance, which is based on ancestral model law, is the applicable law to the arbitral procedure. So I should say, before you put HKIAC Shanghai office as a seat in your arbitration clause, please ask yourself whether you mean to have a hearing at HKIAC Shanghai office, or you mean to have Shanghai as a seat for the arbitration. So to understand the difference between the seat of arbitration and the hearing place of arbitration is the very key starting point. So for today's webinar, foreign arbitration institution administering arbitration in mainland China over the past 5 years, we have seen many developments here. So for judiciaries, Shanghai Court and the Guangzhou Court further clarified offshore arbitration institution administering arbitration cases in mainland China last year. For the State Council, the Shanghai and the Beijing local government, they seem to open their arbitration market to offshore arbitration institutions, but it still remains some questions that need to be answered and discussed. So today, we are very fortunate to have 2 prominent experts join us, Jinzhou Tao and Renfei Ang QC. So Mr. Tao is an arbitrator at arbitration chambers. He has sat in over 200 arbitrations, the majority as a sole or presenting arbitrator. He has been consistently recognized by the Legal 500 Asia and the Chambers Global as the leading dispute resolution lawyer in China and one of the most in-demand arbitrators in Asia-Pacific region. Renfei Ng is the Queen's Counsel at 7 BR barristers' chambers. He is an experienced counsel specializing in commercial litigation and arbitration with more than 18 years experience appearing before courts and tribunals and also sitting as an arbitrator in different jurisdictions. He was one of the youngest Queen's Counsel to be appointed in 2018. So Jinzhou and Renfei, thank you so much to agreeing to contribute to today's event, and I look forward to have a productive discussion with you later. So our today's webinar will have two parts. First, we will have a panel discussion with our two guest speakers on 5 group questions, and then the session will be devoted to 15 minutes Q&A round. So dear audience, if you have any questions related to our today's topic, you are encouraged to resort to the Zoom's Q&A function, and we will try to answer your questions later. So before we proceed to our first part, panel discussion, I would like to raise a polling question for all the audience. Okay, so now you can see the polling question on your screen. So you can only choose one of the answers. So as a counsel, which arbitration clause would you generally recommend for your clients in contracts involving Mainland Chinese element? Option A, offshore arbitration institution, for example, HKIAC, with unsatural model law jurisdiction, for example, Hong Kong. Option B, offshore arbitration institution, for example, Hong Kong IAC, with mainland seat, for example, Shanghai or Beijing. Option 3, onshore arbitral institution with mainland seat. Now you have 10 seconds to choose. 5 seconds. 2 seconds. Okay, so let's see the result. Good. Around 70% people choose the option A, and around 20 people choose option B. So we will raise the same polling question again after our panel discussion, and we will see whether those numbers will change or not. So without further ado, let's begin our panel discussion. So for the first question, so I would like to ask Renfei first. So I just mentioned seat of arbitration might be the most important conception in international arbitration. Would you please introduce that what legal significance does the seat of arbitration carry in international arbitration? Thank you.
Well, thank you, Ling. Firstly, many thanks to you, Ling, and to the HKIAC for this invitation to speak at this webinar, and a very good afternoon, good morning, good evening, ladies and gentlemen, wherever in the world you may be. It is a very topical issue that we are discussing in the course of this webinar. And the answer linked to the first question as to what is the legal significance of the seat of arbitration. In fact, there are 4 things in particular that are worth taking into consideration so far as the legal significance of a seat is concerned. The first is that the determination of the seat of arbitration determines whose laws will govern the arbitral process, in other words, determining the curial law of the arbitration. The second is that determination of the seat will determine whose courts have supervisory jurisdiction over the arbitration, for example, and including but not limited to the power to set aside the award or jurisdictional rulings. The third is that the seat will also to be considered to be the jurisdiction in which the arbitration award is made for the purposes of the New York Convention. And fourth and lastly, but certainly by no means least, where there is an absence of an express or implied choice of law, the applicable law of the arbitration agreement and thus its validity will usually be most closely connected with the seat of the arbitration. And this is obviously a reference to an issue that was very recently decided by the UK Supreme Court in a case which no doubt those of you who are experienced arbitration exponents will be familiar with. It's the decision of Enker and Chubb. See the majority view at paragraphs 141 to 144, which in a very broad sense also tracks the discussion in many other jurisdictions in terms of the connection between the law applicable to the arbitration agreement on the one hand and the determination of the seat on the other.
Thank you, Renfei. Very important legal conception rather than physic place. So the same question I would like to ask Jinzhou. Jinzhou, do you think this significance of the seat of arbitration is well reflected under Chinese law?
Yeah, the answer is yes and no. No, in the sense that traditionally China will only take into consideration the place of arbitration institution, not place of arbitration when they fix the nationality of the place of arbitration award. Only in the last 10 years or so, China has progressively recognized the importance of place of arbitration. One instance, for example, in 2017, the Chinese foreign related relationship law saying that you can go to place of arbitration or place of arbitration institution. So they take these two elements into account. I recall that in 2004, in one Chinese Supreme Court decision, they basically said that for our work rendered in Hong Kong by ICC, they said, look, this award, we should not use Hong Kong arrangement with Mainland, but we have to use the New York Convention signed by China, so that since ICC is a Paris-based institution, then we'll use New York Convention. They consider that this nationality of this award is French instead of Hong Kong. So now, in the last several years, they will only consider the place of arbitration and no longer the place of arbitration institution. So you have this evolution of Chinese attitude towards the place of arbitration and place of arbitration institution. So I think now China is more in line with the international practice, which means that they will only take into consideration the place of arbitration instead of place of institution.
Thank you, Jinzhou. You just mentioned the foreign-related applicable law, the conflicts of laws in Mainland China in 2010. So actually, for our last session, we discussed this article carefully about how to determine the applicable law of the foreign-related arbitral agreement. So which states that if the parties have no choice or have party autonomy, have no party autonomy on the applicable law of arbitration agreement, the seat of arbitration, the seat or the place of the arbitral institutions, the two of the laws would be applied to the arbitral agreement. Thank you, Jinzhou. Very important introduction. So the second question for both of you, and you just give a very brief introduction between the seat of arbitration and the place of arbitral institutions, the dynamics between two. So would you please give more examples whether how the concept of seat of arbitration be established as a legal term of the art in China legislation. So would you please give more details or give more examples about that? Jinzhou, please.
Yes. In that case, you may want to go to next slides, where we quoted the Chinese arbitration law, China civil procedure law, and also the law of, applicable law for foreign related civil relations, where you can see that in the early days, they only refer to arbitration commission's place, while later in 2000, they started to take into consideration both arbitration commission and the seat of arbitration. So then the question is, what about the conflict? Which one we should pick? We should put arbitration commission on priority or the seat of arbitration on priority. So, and if we read literally this law, is maybe we should first refer to arbitration commission. And only if there are no arbitration commission, then we can go to seat of arbitration. Because in China, traditionally, China does not recognize the ad hoc arbitration. So every arbitration rendered in China is supposed to be institutional versus ad hoc arbitration. And also I mentioned earlier that even when we deal with arbitration rendered abroad, the Chinese court initially will only consider the place of arbitration institution, not the place of arbitration. It happens that maybe in one case, the place of arbitration is the same than place of arbitration commission, but in case of HKIAC or in case of ICC, they are not necessarily have the same the institution and the place of arbitration in the same city or same country. So that's why you have to figure out what's the nationality of this award. And now Chinese Supreme Court seems to confirm that they will only consider the place of arbitration, not the place of arbitration institution anymore.
Okay, good. Thank you, Jinzhou. So for these slides, for this page, I would also give some clues for our audience today that although the seat of arbitration is not adopted in Chinese law, but recently there are arrangements between Mainland China and Hong Kong on the enforcement of arbitral award. For this specific arrangement, the doctrine or the concept of the seat of arbitration has adopted for the Hong Kong and Mainland China enforcement arrangement. So for Renfei, the same question. So do you see any dynamics between the location of arbitral institution and the seat of arbitration and the other jurisdictions? For example, London or other jurisdictions you are familiar with?
Well, Ling, from an international practitioner's perspective, to my mind, there is a trilogy of recent cases by the Chinese courts which are particularly important in reinforcing, obviously, the emphasis on seat of arbitration, and in particular, in giving effect to foreign-related arbitrations which are administered in mainland China. This is what I call the trilogy of cases. I think Tao Laoshi mentioned one of them, which is the Long Leader case, which is a Supreme People's Court decision. There is then a second decision which is called Dasung or Dasung and Brentwood China Investment, which is a decision of the Shanghai #1 Intermediate People's Court. And allied to that, the same case was also adjudicated upon by the Singapore Court of Appeal, reported as BNB and BNA. And the third of the trilogy is the decision of Brentwood, which is a decision which took place last year, and it's a decision of the Guangzhou Intermediate People's Court. There are, to me, 4 key takeaways from this trilogy of decisions and why it entirely comports with modern arbitration jurisprudence in other jurisdictions. The first, to me, is that this trilogy of cases, Longlida, Dasung, and Brentwood, demonstrates a strong pro-arbitration position by the PRC courts, as high up as the Supreme People's Court in general, and in particular, to clearing legal obstacles for foreign arbitration institutions or offshore arbitration institutions, to be precise, like the HKIAC, to enter the mainland Chinese market. The second important takeaway, Ling, is that the pro-arbitration approach of the PRC courts in this trilogy of cases is even more significant and is underscored and bookended by the fact that when you look at the cases like Longlida and Dasung, which deal with the validity of the arbitration agreement on the one hand. So in other words, it deals with an issue that arises at or near the start of the arbitration process, by comparison with Brentwood, which deals with enforcement of awards on the other hand, and thus at the other end of the arbitral process after the arbitration has completed. The underlying decision in this trilogy of cases, irrespective of whether you analyze it from the Longlida and the Dasung aspect, which is near or at the start of the arbitration process, or from the Brentwood perspective, which is at the end of the arbitration process, nevertheless are all consistent because they again reflect the pro-arbitration enforcement approach of the PRC courts, and in particular in clearing legal obstacles for offshore arbitration institutions to operate in mainland China. The third key takeaway from an international practitioner's perspective is a little known fact that, to my mind, and this I think imports a broader dimension to the debate, is that this trilogy of cases further reinforces the pro-arbitration approach of the PRC courts in this respect. Now, the party that ended up prevailing in each of Longlida, Dasung, and Brentwood in respect of the issue as to whether an offshore arbitration institution can validly administer an arbitration in mainland China, and therefore to do with the validity of an arbitration agreement, for example, that provides for ICC arbitration in Shanghai or HKIAC arbitration in Shanghai or Singapore arbitration in Shanghai, was all resolved in favor of the non-Chinese party against the Chinese party. It's not a well-known fact, and I think this dispels the myth and misperception that so far as arbitration is concerned, there might be said to be a territorial approach that is adopted by municipal courts in many jurisdictions, including, it might be said, China. Not so, because when you look at the evidence in terms of the outcome of the decisions in this trilogy of cases, all of them, without exception, went against the Chinese party, including in Brentwood, where the Chinese party in that case, which was Guangdong Fa Anlong, was asking for the court to refuse enforcement on the premise that an arbitration clause which provided for a foreign arbitration to be administered in mainland China was invalid, and instead the underlying dispute should be submitted to the jurisdiction of the PRC courts. That argument was rejected by the Guangzhou Intermediate People's Court. And I think what this does is demonstrates the impartiality of the PRC courts from the Supreme People's Court to other levels of the courts towards a pro-arbitration approach, irrespective of the nationality of the parties. The fourth important takeaway, in my mind, is that the approach by the Shanghai #1 Intermediate People's Court in Dasung and Brentwood dovetails with the approach of the Singapore Court of Appeal in respect of the same dispute. And it was reported in the Singapore law reports as BNA and BNB, for which the citation is 2020, 1 Singapore law reports 456. And in that case, the substantive contract was expressly subject to PRC law, where it provided for SIAC arbitration and for arbitration in Shanghai. The question in that case is whether the reference to arbitration in Shanghai was a reference to the seat of the arbitration or the venue of the arbitration hearings. It having been argued by Praxair, which was BNA in the Singapore proceedings, that it was to the seat, and that PRC law did not allow foreign-related arbitrations seated in mainland by virtue of the provisions of Article 16 of the PRC arbitration law, and thus the arbitration agreement was invalid. The tribunal didn't have jurisdiction, and the dispute had to be submitted for decision by the PRC courts instead. The Singapore Court of Appeal, in a magisterial judgment that was delivered by Judge of Appeal Justice Stephen Chong on behalf of the court as a whole, applied the well-worn principle articulated by the English Court of Appeal in a case called Naviera Amazonica, for which the leading judgment was delivered by Lord Justice Carr, and held that the reference to arbitration in Shanghai was a reference to the seat. However, having decided that the seat of the arbitration was Shanghai, Singapore Court of Appeal declined to decide the issue of jurisdiction, holding that it was a matter for the PRC courts, the courts of the seat instead, to decide the issue. Thus, the case then returned to the PRC courts, or went off to the PRC courts, and again, in a compelling judgment, the Shanghai No. 1 Intermediate People's Court, applying the Supreme People's Court reply in Longlither, held that the arbitration agreement was valid and rejected Praxair's submission that there was an express prohibition under PRC law for foreign arbitration institutions to administer foreign-related arbitrations in China. This, to my mind, brings the approach of the PRC courts within the firmament of modern jurisprudence on arbitration in other jurisdictions. And more importantly, you can sort of see the dovetailing of the approach by the Singapore Court of Appeal in BNA and BNB, and by the PRC courts, in this case, the Shanghai No. 1 Intermediate People's Court, applying the reply of the SPC in Longlither in order to provide a joined-up approach, which was entirely consistent and all of which was pro-arbitration in nature. So these are, to my mind, the four important takeaways which underscore the pro-arbitration approach of the PRC courts in this important trilogy of cases.
So thank you, Renfei. Very important takeaways and observations on the latest judicial cases in PRC court last year. And you also mentioned 3 leading cases over the 10 years, Longlither, Dasung industrial case, and Brentwood. So I believe Jinzhou will be introducing more details about those 3 cases. And I believe Jinzhou will give more broader picture about the PRC court, the different stages that the PRC court has taken, the different approach over the 20 years. So Jinzhou, so my next question for you is that, would you please introduce the 3 leading cases that the Renfei just mentioned, Longlither, Dasung case, Brentwood, and would you please give your personal observation as a Chinese practitioner, because Renfei just gave comments as an international practitioner. So please, Jinzhou.
Yeah, thank you. I recall that in the early 2000s, Mr. Dr. Robert Brunner, a former chairman of ICC court, visited China many times. And I was a court member, so I go with him. He said, look, he told the Supreme Court of China saying that ICC can conduct arbitration all over the world, but why not in China? And we even think maybe we should fabricate an arbitration case so that we will test whether Chinese court will deny enforcement or not. But fortunately or unfortunately, in 2003, we have this Zublin case. Zublin case where the arbitration clause provided that is ICC rule, Shanghai. And the Chinese court said, look, in China, ICC is not an arbitration commission as defined by Chinese court. Therefore, we should not enforce this arbitration award. So maybe Zublin award should be considered as a no domestic award and the New York Convention. But since China made a reservation when they joined the New York Convention for only recognized award rendered in other signature territory, and therefore we should not enforce Zublin case. And then after Zublin case for quite some time, you know, a lot of foreign institutions such as ICC, HKIAC are very skeptical as to whether they can contact arbitration if place of arbitration is defined as in one of the cities in China. And then even before only the case come out, you have some zigzag of Chinese court, local court in Ningbo and other cities. In one instance, they said, okay, we should enforce arbitration with rendered by foreign institution, but with a place of arbitration in China. And some other courts said, no, we should not enforce. And for those which were not enforced, were approved by Supreme Court. You know that in China, we have this pre-reporting system where local court can only deny enforcement. If they want to enforce, they can go ahead to enforce. So before only all the enforcement case were rendered by local court without approval of a Supreme Court. I think only the case is for first time, the Supreme Court said, look, if it's provided for ICC arbitration with place of arbitration in China, and ICC should not be considered as a no arbitration commission as defined by arbitration law. So they give a broader interpretation of arbitration commission, saying that arbitration commission should not be defined as those registered in China by Ministry of Justice. If it's an institution, it should be considered as arbitration commission. So that's why you know, we have this very interesting Lin-Gang case, and the rest of the case are already in the history. So Jianfei already mentioned that I'm not going to the details. And also, you know, Jianfei mentioned about a Singapore case. In Hong Kong is the same, because when in the ICC case, if they said the place of arbitration in China, the Hong Kong court dealing with this matter, saying that since Mainland China, it's not clear whether foreign arbitration institution can contact arbitration. Therefore, since Hong Kong is a part of China, I will fix the place of arbitration in Hong Kong instead of in one of the cities in Shanghai or Beijing. So this Chinese court's attitude towards arbitration clause have a major impact over the foreign judges' attitude, whether they should let the case go to Mainland China or keep somewhere in the world.
Thank you, Junzhou. You have given our broader picture about how the zigzag, the approach that the parties have suffered before PRC court. But fortunately, since last year, we have seen, as Renfei just mentioned, that the Supreme People's Court have taken more pro-arbitration approach, like other pro-arbitration jurisdictions, Singapore and Hong Kong. So good. So the next question, question number four. So we understand that over the past 5 years, so just now we have talk about the judiciary development. Now let's move to the policy development. So we understand that over the past 5 years, the Chinese government has issued several policies in Shanghai, Beijing, and Hainan to support offshore international arbitration institutions to conduct business in Mainland China. In particular, next slide, please. So I would like to introduce the next slide, please. So I would like to introduce the general policy development. In particular, in 2019, the State Council issued a master plan for the China-Shanghai Free Trade Zone in Lin-Gang special area, which proposed that well-known offshore arbitration institutions shall be allowed to set up case management office in Lin-Gang special area. In the same year, the SPC issued the judicial opinion to support the State Council's plan. In 2020, last year, the State Council issued the similar plan to support Beijing Free Trade Zone. In the same year, the SPC issued the judicial opinions to support the State Council's plan in Beijing. Earlier this year, SPC also issued the third judicial opinions regarding Hainan Free Trade Port, in which SPC encouraged offshore arbitration institutions to set up a business office and provide arbitration services in Hainan Island. So Renfei and Jinzhou, so we just talk about the judicial development, and these slides have shown the policy developments over the 5 years in Mainland China, how the Chinese government seems to open its market to offshore arbitration institutions. So my question for this part, so generally, what do you think of those arbitrations administered by offshore arbitration institutions with a mainland seat? And specifically, I believe you guys still remember our polling questions at the very beginning, that as a counsel for the parties, what's your preference? What's your choice for the polling questions as a counsel? Who want to go first? Renfei, please.
Well, I think the answer to your question, Ling, is it depends. I think it depends because there is much to be said for HKIAC arbitration, for example, seated either in Hong Kong or in mainland China, as there's a slide that you've just displayed demonstrates. Perhaps one of the critical differences between a Hong Kong seat and a Beijing or Shanghai or some other mainland seat would be, amongst other things, the question over whether or not there is availability of interim measures from the PRC courts as the court of the seat if the arbitration is seated in Beijing or Shanghai. Now, I can naturally see how it would be instinctively attractive for many end users to say, oh, well, if there is certainty or certitude of interim measures being available from the Hong Kong courts, if the seat of the arbitration is Hong Kong, then we would opt for offshore arbitral institution plus Hong Kong as the seat of the arbitration. However, can I just offer maybe a slightly counterintuitive view? The reason why I say it depends is I think it depends, firstly, on whether or not as counsel for client, your client is perhaps the sort of client who, the question is whether or not they are more likely to be on the applying end or on the receiving end of an application for interim measures. So if you are more likely to be on the receiving end of an application for interim measures, then that would obviously dictate the choice of a seat accordingly, and it may be that you would opt for a seat that makes it more difficult for interim measures to be issued against you by the courts of the seat. However, as a foil, the counterfoil to the counterintuitive argument, I would say that ultimately the difference may not matter all that much because, and here is an advert for HKIAC arbitration, come what may, is that under the rules of the HKIAC rules of arbitration, and I know it well, not least as a member of the HKIAC's proceedings committee, is Article 23.3 of the HKIAC rules, or Article 23 of the HKIAC rules, let's start there, makes it quite clear that for an HKIAC tribunal, and of course this doesn't matter where the seat of the arbitration is, interim measures can still be issued by the tribunal. This, interestingly enough, includes an application for emergency relief, and therefore for relief which might be said to be similar to what you would apply for by way of interim measures, for which the HKIAC rules has a specific provision in the rules. This is Schedule 4 that deals with emergency arbitration, including emergency relief. Article 23.3, which I briefly mentioned just now, makes it clear that the interim measure can assume the form of an order or an award or some other form. And paragraph 12 of Schedule 4 to the HKIAC rules, this is the 2018 edition, in relation to an emergency arbitration has got provisions to the same effect. Thus, if and to the extent that you are applying for interim measures in the form of either pursuant to Article 23 and or pursuant to the emergency relief provisions in Schedule 4, there is an option, depending on the circumstances, for the arbitration tribunal or the emergency arbitrator to issue their decision on the relief that is being sought in the form of an award, which arguably would be open to enforcement pursuant to the trilogy of cases that we have just been discussing. So that is the counterfoil to the sort of counterintuitive point I would make. Ultimately, it may not matter. What's far more important is choosing the right set of procedural rules. And it's obviously enlightening that Article 23 of the HKIAC rules in Schedule 4 has got specific provisions that makes it, that facilitates the application of interim or emergency relief off the seat. Plus, can I just offer a practical dimension? I have been involved, I've been instructed as counsel in some 200 arbitration cases over the past 18 years, and I've sat as arbitrator on many an occasion. I ask the rhetorical question, how often is it do parties run off to the courts of the seat of the arbitration to apply for interim measures as opposed to applying for interim or provisional measures from the arbitral tribunal itself? Very rare in my experience. Far more commonplace is an application for interim measures to the tribunal itself. Of course, there is a risk that the party on the receiving end of the interim measures will not abide by, will not comply with the order for interim measure. But for a party who wishes to continue participating in the arbitration proceedings, they any failure to abide by an order for interim measures made by the tribunal is done at the non-complying party's own risk, because obviously there's no point in, as the English saying goes, cutting your nose to spite your face, if in the circumstances you wish to remain in the arbitration proceedings and ultimately wish to persuade the tribunal of the underlying merits of your case. So that would be my analysis in terms of the difference in seats. I think what is far more important is choosing the applicable set of procedural rules, although I can obviously instinctively see why it might be said that if you have certitude about the support of the courts of the seat, for example, in Hong Kong, for interim measures, there might be an inclination to opt for, say, HKIAC arbitration and a Hong Kong seat. But all is not lost, even if you were to pick a mainland seat, because of the safeguards that have already been bolted into the HKIAC rules in that respect.
Thank you. You mentioned a very important issue by comparing the different seat interim measures. So Hong Kong is a unique seat in China. That is the unique jurisdiction, the only jurisdiction outside of Mainland China. The parties to Hong Kong arbitration, especially for HKIAC arbitrations, can get interim measures before Chinese court. This is the most important consideration for counsel, maybe to advise your client. So the same question for Jinzhou. As a Chinese practitioner, so what's your preference for such different arbitration clause arrangements?
Yeah, first, arbitration clause is always a bargain of the party, even though I advise one companies that may not have a sufficient leverage to be accepted as the clause arbitration in the future. So overall, I think choosing offshore arbitration institutions with the place of arbitration abroad versus in China, they are always have a pro and a con. For example, if you choose HKIAC, say in Shanghai, the problem is the Chinese court and the Chinese arbitration law can order HKIAC to stop the procedure if another party challenge the validity of arbitration clause. So HKIAC in that case must stop the procedure, waiting for the court to decide whether arbitration clause is valid in order to pursue the future arbitration. If a court said it's not valid, the court will take on the case and go to the litigation. If a court said it's a valid arbitration clause, then HKIAC Shanghai can pursue the arbitration. So you have this anti-arbitration injunction possibility, which is much stronger than in other countries. On the other hand, Jianfei mentioned about interim measures other than Hong Kong, where you have this special arrangement to enforce interim measures. And if it's the offshore arbitration in Singapore, for example, the arbitration tribunal, if they want to issue interim measures, they cannot be enforced in China. So dealing with Chinese parties is maybe a problem. Also, on the interim measure side, under the Chinese arbitration law, the foreign arbitration institution with the place of arbitration in Shanghai, they cannot issue interim measures. Interim measures can only be issued by the court of Shanghai. Of course, now China tried to amend the arbitration law. I somewhat get involved, so I cannot disclose too much. But I hope that in the future, the Chinese arbitration tribunals will have the power to issue interim measures like other tribunals in other parts of the world. So we'll see how this is going to develop with the forthcoming amendment of Chinese arbitration law.
Okay, thank you, Tao Laoshi. You mentioned another very important issue, that the judicial review with the different seats. If we choose Shanghai as a seat, even for those offshore arbitration institutions, the tribunal should wait till the local court give the decision on the validity of arbitral agreement. But if the seat is outside of Mainland China, the tribunal to the offshore international arbitration institutions has no legal duty to wait till the PRC court made the decision. So very important observation. Thank you so much. But I want to give further questions, because I understand both of you have been sitting as an arbitrator in many different jurisdictions. So what I want to change another angle. So for as an arbitrator, do you think or do you see any certainties or uncertainties to sit as an arbitrator in the seat of unsettled model law jurisdictions such as Hong Kong or Singapore, or any difference as a seat in China as an arbitrator?
Personally, I did not see any difficulties, but there are, many other, detailed issues need to be resolved. For example, the, tax treatment for arbitrators' fee, the travel facilities for arbitrators and the foreign counsel, and also some logistic issue, although improved in China, but still, needed to be improved in the future, so that we can have a more, efficient contact of arbitration proceedings.
Renfei?
I entirely echo Tao Laoshi's viewpoint on that. I personally don't see any difficulties, and whether sitting in mainland China or Hong Kong or some other UNCITRAL model law jurisdiction, or even in England, which is not an UNCITRAL model law jurisdiction. what is the common denominator between, say, for example, an arbitration seated in Beijing, Shanghai, Hong Kong, London, or Singapore, is the fact that all of these jurisdictions have got comprehensive modern arbitration legislation. There is a very strong pro-arbitration support from the executive branch, obviously in promoting arbitration. And there is also a cadre of excellent arbitration practitioners whom I have the pleasure of listening to and who appear before me in different jurisdictions. And to be honest with you, I think diversity of experiences is what makes sitting as an arbitrator or indeed appearing as counsel so interesting and exciting. I cannot think of anything more boring than having a monotonous experience across the board. And I much enjoy sitting, whether in Hong Kong or Beijing or London or Singapore. And to the extent that there are differences, for there will be some minor and some perhaps not so minor, I celebrate those differences because it enhances the experience I get as an arbitration practitioner.
Okay, good, thank you. Thanks a lot for Jinzhou and Renfei's sharing. So with these two leading international arbitration experts' opinion in mind, I would like to raise the polling questions, the same polling questions again. So now, dear audience, now you have 30 seconds to choose. I would like to see whether the number have changed or not. Yes. Ten seconds. Five seconds. Okay, let's see the result. Okay, very similar numbers as the first polling question. So I believe our audience, most of our audience are very experienced practitioners. So congratulations to our speakers. So before we move to the last question for today's webinar, I would like to encourage our audience to resort to Q&A function to raise your questions, and we will answer your questions later after the final question. So last question for Renfei and Tao Laoshi. So this is a quite open question. So what is the prospect for offshore international arbitration institutions to conduct business in Mainland China? Do you expect to see more parties to resort to the offshore arbitration institutions to administer arbitrations with the seat in Mainland China? Tao Laoshi, Jinzhou.
I think it's a good development that finally offshore arbitration institution can conduct arbitration in China. This is good. Competition is always good for improve yourself and also for the users of arbitration, for lawyers, arbitrators, and the companies. So, but in the future, it really depends on how the future arbitration law will be and how friendly the Chinese court towards arbitration will be, and whether it will be continue in the improvement or there are any, I hope not, some backward, like Dr. Brinner said some years ago, we should not have, two step, forward and one step backward. I hope that we'll keep this, open-minded so that we'll create a really level playing field for foreign arbitration institutions in China and domestic arbitration institutions. So fair competition is very good. I hope it will be continue.
And I echo everything that Tao Laoshi has said. I think the short answer to your question what is the prospect for offshore arbitral institutions to conduct business in mainland China, Ling, it's a bright one. But more importantly, to my mind, it underscores the fact that the prospects and growth and development of international arbitration in China is a positive one. And the reason why I say that is because it's really an intersection or a confluence of three different factors in particular. The first is that we have seen this evolving jurisprudence of pro-arbitration decisions from the Supreme People's Court down to the Shanghai No. 1 Intermediate People's Court and the Guangzhou Intermediate People's Court, which, bear in mind, Long Leader was in 2013. So this is close to 10 years ago. We've seen this consistent bedrock of pro-arbitration judicial decisions, which is an important factor. Second important factor is the fact that you have strong support by the State Council, by the central government, and also obviously by regional governments in the promotion of arbitration. We've talked about, for example, the free trade zone plan for Shanghai, Beijing, and Hainan, as an important indicator or yardstick of governmental and policy support, policymaker support for the development of arbitration. And third is the fact that, and I'm seeing this in the course of the work which I do, again, I spoke about it very briefly just now. I refer to it as the growing cadre of excellent arbitration practitioners. And by that, I am referring to excellent arbitration practitioners and arbitrators, particularly in the younger generation, who are practicing in China. And also the fact that you have seen a growing number of international practitioners who either practice in China who are or involved otherwise in arbitrations involving Chinese parties, all of which will only contribute, I think, to the popularity and growth of international arbitration in China. So the answer to question number 5 is based on the evidence of what we have seen in close to the past 10 years, whether in terms of judicial decisions, policy support, or what we are seeing on the ground in terms of skills and knowledge, is that the prospect for offshore arbitral institutions to conduct business in mainland China is a bright one. Indeed, the growth of international arbitration in China as a whole is one which is clearly a positive one. And the best bit is we've only just begun, and the best, I believe, is yet to come.
Thank you, Renfei, and thank you, Tao Lao Shi. So I just want to give some comments on Renfei's answer to this question. So I believe we can conduct another webinar, maybe several years later, when offshore international arbitration institutions, some of them have set up case management office in mainland China. We come back again to say what happened and how the development goes. Now let's move to the Q&A session. Right now we have several questions. Oh, many questions come through, and the first question I want to give to Renfei. This question from Kevin. He asked, Mr. Ng QC, recently the Chinese government seems to be opening its market for foreign arbitration institutions. How do you think it will impact the arbitration market in China and in Asia Pacific region? Renfei?
Yes, thank you very much to Xiao Shan for the question. And the answer is that it will, perhaps building on the last answer which I gave to question number 5, it will result in the growth of arbitration in China and in the Asia Pacific region. But on a more granular level, it will result in the growth and development of arbitration practitioners and arbitrators in China. It's all obviously trending in the right direction, a very pro-arbitration decision, pro-arbitration sentiment. And therefore, I think the short answer to your question is that it will result in even greater growth of the arbitration market in China and perhaps more wider in the Asia Pacific region.
Okay, thank you. You know the question raiser, Xiao Shan. Oh my God, Renfei, you understand China very well. The second question, I want to give it to Jin Zhou. This question came from Zhe Yu Pang. This question looks like this: a question about the source of authority of the theory of PRC law. Long Leader and Brentwood precedents from Chinese court and by civil law nature of PRC law, these precedents are not binding. Where there be any constitutional problem, if the PRC court, especially the SPC, overread the current PRC law, so actually this question always come from the international practitioner to question whether the PRC court or SPC's case have a binding source on the lower court. Yes.
One anecdote is when I visited the Supreme Court and China National People's Congress legislature in China, Dr. Brenner went to Supreme Court. Supreme Court at that time, early 2000, said, you must go to legislator. They have to amend the law so that we can include the foreign arbitration institution in China. Then I went to a legislator. Legislator said, you need only interpretation of a Supreme Court, then we can resolve the problem of the foreign arbitration institutions, contact arbitration. So now it seems like Supreme Court had made a decision saying that they will move ahead regardless whether the law will amend it, because under Chinese constitution, Chinese court not only deal with individual case, they also have a power to interpret the law. So they have a general applicability of such judicial interpretation of the law. So there are no issue of constitutionality or control of a constitutionality issue. The Supreme Court can do that. It's not going to breach the Chinese constitution by allowing the foreign arbitration institutions to conduct arbitration in China.
Okay, thank you, Junzhou. I have seen the similar question from Mr. Andrew Poland. I believe Andrew based in Singapore. And I want this question goes to Renfei, the similar question. So how confident can parties be that a foreign institution can administer a case in Mainland China based on the cases we have mentioned below, given that China does not have a common law strict doctrine of precedent and statutory provisions appear not to have been amended yet. Renfei?
Yes, well, obviously, Ling, I can, so far that this is a question that pertains to the substance of PRC law, I would obviously have to defer to Tao Lao She on that. But looking at this from an international practitioner's perspective, I am an optimist, as I think you will have gathered from my contributions thus far in this webinar. True it is that there isn't a binding system of precedent in China in the same way that there is in the common law systems. But having said that, though, I think it is very significant, for example, that the Long Leader decision, the reply of the Supreme People's Court, was one that was obviously issued by the apex court of the People's Republic of China, and that the consistent body of cases. So when you talked about the zigzagging, there is, true it is that there was a bit of zigzagging, for example, with Zublin, for instance. But in terms of you look at what's happened since 2013, to the extent there isn't very much of a zigzagging. Instead, you have this sort of this constant trendward trajectory, all of which is very pro-arbitration. And the significant thing, and I mentioned this earlier on in my webinar, I said an interesting fact that very few people emphasize on, is the fact in the trilogy of cases, Long Leader, Dasung and Brentwood, it was the non-Chinese party which ended up prevailing on this issue. So true it is that there's no binding system of precedent, but even then, even with common law systems, it is always open to an apex court, albeit it is difficult, admittedly, to depart or distinguish from previous decisions. There's no such thing as 100% certitude. But if one were looking at the trends and the evidence, the fact that you have this body of case law that dates back almost 10 years, all of which is trending in the right direction, combined with the strong support of the state council and regional governments for arbitration, for example, in Shanghai, Beijing, and Hainan, all trends in the right direction, such that I think it can be safely said, with some measure of confidence, that offshore arbitration institutions can effectively administer arbitrations in mainland China.
Okay, thank you. Maybe we have a last question. I want to give it to Mr. Tao. Glatter, the question came from Glatter. Glatter said, please permit one question to Mr. Tao. When can the revision of the PRC arbitration law be expected, and which might be the most important issue to be revised? Mr. Tao?
With the time constraint, I maybe one sentence answer. The whole team is working on that. I hope that within 2 years or so, we'll get the new law passed.
Okay, very quick answer. Thank you. So again, thank you so much, Renfei and Tao Laoshi. Before we finish, I would like to offer a few takeaways from today's webinar. First, we should note that in Mainland China, submitting foreign-related dispute to an offshore arbitration institutions is not a new development. It can be, under Chinese law, PRC law, at least starting from the 1980s, the foreign arbitration dispute can be submitted to the offshore arbitration institution. Second, for a long time, mainland courts' opinion regarding the validity of the arbitration agreement of submitting disputes to offshore arbitration institution with mainland seat is unclear. Until 2013, in Longlide case, the SPC finally made it clear that such arbitration agreement is valid. Third, last year, in 2020, the Brentwood case, as we discussed today, the Mainland Court made it clear that to enforce an arbitral award which is administered by an offshore arbitral institution with mainland seat shall be under PRC civil procedure law instead of New York Convention. Fourth, we still need more cases and SPC judicial opinions to say whether interim measures could be supported in mainland court and which competent court could set aside in arbitration administered by an offshore arbitration institution with a mainland seat. Lastly, as we mentioned in the first question in this webinar, the seat of arbitration is very important to parties. When the parties are dealing with an agreement that involves mainland China interest, they should be prudent with the choice of the seat of arbitration. As most of you know that this month, Queen Mary and Whiteland case published the 2021 International Arbitration Survey, which shows that Hong Kong is the third most preferred seat in the world. I believe Hong Kong was and is still going to be a neutral and popular seat of arbitration in the world. Moreover, as we discussed today for our today's webinar, especially for the dispute that may involve mainland China interest, thanks to the PRC Hong Kong interim measures arrangement and arbitral award enforcement arrangement, choosing Hong Kong as a seat could provide parties with many certainty, convenience regarding interim measures and enforcement. So let's conclude today's webinar, the second session of HKIAC Chinese Arbitration Insights webinar series. Thanks, Renfei. Thank you, Tao Laoshi. Thank you, everyone, for participating in today's event. And we look forward to see you all in our next session. The topic of our next session will be the mainland China and investment arbitration. Thank you.
Thank you very much.
Thank you.
Thank you, Renfei. Thank you, Tao Laoshi. Thank you, Jinzhou.
Bye.
Goodbye. See you next time.